This is the second module of the DMAS Appeals Division overview. This module will address the overall process of DMAS appeal hearings. This module will cover the following topics: a client's right to an appeal and the applicable laws, common appeal issues, the Denovo Appeals process, significant client appeal forms, the client appeal processing timelines, the responsibilities of the hearing officer, and appeal decisions. Within the Appeals Division, client appeals take two forms. First, the Appeals Division handles appeals regarding eligibility determinations, including denials, terminations, and reductions of coverage. We also handle appeals regarding denials of specific medical services. On this slide, you can see the various issues that fall into each category. The most common eligibility appeals relate to applications and renewals for which documentation is missing from the file and the agency is unable to determine or redetermine eligibility. We also receive a significant number of appeals for applications that the appellant alleges have not been addressed in a timely manner. The Appeals Division also has authority to hear appeals from recipient audit unit actions to recover misspent funds directly from appellants. On the medical side, the Appeals Division hears a significant number of appeals related to the provision of medical services, the most common of which are pre-admission screenings, personal care hours, dental, and nursing home discharge appeals. Several sources of law govern the Medicaid state fair hearing process. First and foremost, the Code of Federal Regulations, or CFR, mandates that DMAS maintain an appeals forum and sets out several core requirements of the process, such as key procedural rights of appellants and required timeframes for completing the process. There is a separate section listed above that specifically regulates the appeal system for decisions made by managed care organizations associated with the Medicaid program. Further, the Virginia Administrative Code distills the core principles contained within the CFR to provide more detailed guidance regarding how Virginia's state fair hearing process works, and Chapter M16 of the Medicaid Policy Manual provides specific details about how the DMAS Appeals Division operates and outlines the expectations for clients and agency staff when dealing with the Appeals Division. Finally, when an appellant disagrees with the final DMAS decision, they have recourse to an appeal at the appropriate local circuit court. The rules that they must follow to perfect an appeal to the circuit court are contained in the Rules of the Supreme Court of Virginia, a copy of which is provided with every final DMAS appeal decision. The CFR outlines when the DMAS Appeals Division must grant a fair hearing, and the list is rather exhaustive. On this slide, the first two items relate to client eligibility appeals, and the rest relate to medical issues. When it comes to eligibility, we are required to grant a hearing when a member has been denied or terminated or otherwise believes that an action on their case has been taken in error. Further, please note that they may also appeal a local agency's alleged failure to process an application within the specified deadlines for issuing an eligibility notice. Please also note that DMAS has the authority to hear appeals over nursing facility discharges or transfers, even when the appellant is not a Medicaid member. DMAS may order that the appellant remain in the facility during the course of the appeals process. We also hear screening appeals for long-term care eligibility and MCO determinations once an appellant has exhausted an MCO's internal appeals processes. Finally, we hear transportation appeals if a non-emergency transportation request has been denied. Note, however, that under federal law, we are not required to provide a member with a hearing if the sole point of disagreement is a matter of state or federal law. U.S. Supreme Court case law also provides requirements on what we must do to provide effective procedural due process to Medicaid clients. Goldberg versus Kelly was a public benefits case in which coverage was terminated with no prior notice or right to be heard to argue against the decision. The court held that due process is not only a criminal right, but applies when any government action comes under scrutiny. The case decision specifically enumerates the procedural rights that apply to all public benefits appeals, including advance written notice of any adverse determination related to their case. They must also be provided with a neutral forum in which they may present testimony and evidence as to why the decision was made in error. In concert with this right, they have the right to examine any and all documents that were used to make an adverse determination in their benefits case, so they may adequately question the agency's action. Further, they may hire an attorney or bring a representative to the hearing to act on their behalf. And finally, Goldberg stipulates that the appellant is entitled to a decision based entirely on the facts of their case through evidence provided during the appeals process and the laws and regulations that apply to those facts. Now it's time to discuss Denovo Appeals and how they fit into the appeal summary requirement. This is a relatively new procedure that we have adopted based upon federal law, which is designed to render a new eligibility determination for members who engage the client appeals process. In practice, all appeals are to be conducted as de novo appeals at this point. The procedure requires that the hearing officer issue a new eligibility decision back to the date of the original application or termination, and that they must consider any new relevant evidence even if it was not in possession of the DSS at the time of the original determination. That means that appellants may submit additional documentation at any time during the appeals process, and the hearing officer's decision must take that documentation into account and discuss any new evidence and why it supports the original decision or requires a reversal. If possible, the hearing officer is to render an entirely new eligibility determination based upon the evidence presented during the appeal. As a result of this process, there are new requirements for DSS workers as it applies to the appeal summary. The first is that the DSS worker must evaluate any new documentation received with the notification of the appeal or submitted at any other time during the appeals process, even if they didn't have it when they made the original decision. Next, the DSS worker must evaluate whether the new documentation would change their original decision. If the documentation would require a new decision, then the DSS worker must issue a new notice of action describing the coverage to which the appellant is entitled and send it to the parties. The hearing officer will review the new notice of action and determine whether or not the appeal is resolved. The new notice of action is not a replacement for the appeal summary, which we'll discuss later in this module, but may result in an administrative resolution of the appeal. However, if the new documentation does not result in new coverage or a resolution of the appeal, then the eligibility worker must prepare a Medicaid appeal summary to address the original decision, new documentation, and be prepared to participate in a hearing to explain why the original decision is still correct, considering the new documentation. When the hearing officer issues a final DMAS decision, it will encompass the entirety of the record, including any new documentation received throughout the process. The Appeals Division has the authority to review eligibility and medical denials, terminations, and reductions from the agencies listed on this page. On the eligibility side, the most common agencies are local departments of social services. However, Cover Virginia appeals also account for a significant portion of the eligibility caseload. The eligibility team also handles appeals from other DMAS divisions, including HIP determinations, emergency services denials, recipient audit unit and fiscal recovery actions, as well as undue hardship determinations. On the medical side, a significant portion of appeals come from local health departments, MCOs, and decisions from the Department of Behavioral Health and Disability Services. There are several responsibilities that fall to the local agency related to the provision of due process. First and foremost, the agency must provide the member with advance written notice of an adverse benefits determination, which describes the action and their right to appeal it. Agencies must also assist members in filing Medicaid appeals if so requested by the appellant. Further, once the DMAS Appeals Division receives an appeal, the division may direct the local agency to continue coverage for the appellant during the course of the appeal and to provide written notice to the appellant and DMAS that this has been completed. During the appeals process, full participation from the local agency is required by providing complete information as to the adverse benefits determination from the case file and preparing an appeal summary by the due date provided by DMAS. As discussed in the preceding slides, the agency must also consider any new documentation that the appellant has submitted during the appeals process to determine whether or not it would change the original determination. Crucially, the agency must participate in the appeal hearing itself by designating an agency representative. The representative should be an individual with detailed knowledge of the appellant's case and is preferably the eligibility worker who took the original action and has reviewed any new documentation. Finally, once the hearing officer issues a decision, the local agency must follow any and all instructions contained within the decision. At times, a worker may not agree with the outcome of the decision, but it's still their obligation to comply with the instructions because an appellant has the right to appeal again if the agency fails to do so. Occasionally, agencies may reach back out to the appeals division for clarification and further instructions regarding remands. However, the division is unable to give any guidance to local agencies that is not already contained in the decision because of concerns about remaining impartial throughout the process. Any processing questions should be directed to the worker's supervisor or the locality's regional Medicaid consultant. While I have already discussed the legal requirements of a denial and termination notice, it's important to reiterate them. To comply with federal law and state regulation, the notice must contain a specific description of the action that the agency intends to take, including a detailed description of the reasons for the action. Further, the agency is required to include a policy citation to support the action. The notice of action must contain appeal rights, describing both the right to appeal the decision as well as instructions about how to do so. Finally, the member must be provided information about the right to receive continued coverage in their original aid category throughout the appeals process. These notices are required to be issued at least 10 days before any of the proposed action is taken. Members are granted a timely filing window for filing their appeals. Under normal circumstances, the Virginia Administrative Code requires that an appeal be filed within 30 days of receipt of the notification. The code presumes receipt of the notice within 5 days of mailing. As a result, the Appeals Division considers an appeal to be timely filed if it is received at DMAS within 35 days of issuance by the local agency. Further, the failure to request an appeal by the 35th day does not preclude access to the appeals process. The appellant may be granted an exception to this requirement if they meet one of the 4 elements contained within the code. Specifically, the Appeals Division will accept an untimely appeal if the appellant was unable to file an appeal because of serious illness, if the appellant did not receive the adverse notice in the first place, if the appellant sent the appeal to another government office, such as the Virginia Department of Social Services Office of Appeals and Fair Hearings, or if they cite any other unusual or unavoidable circumstances that may have prevented filing of a timely appeal. Appeals Division staff will review these requests on a case-by-case basis. Please note that an appeal is deemed to have been received at DMAS on the date on which it's postmarked if sent by mail. Otherwise, it's deemed to have been received on the actual date of receipt for other methods of transmission, including appeals received through the AIMS portal. Please note, of course, that MCO appeals differ from the normal client appeals in that there is a 2-step process. An appellant must exhaust the appeals procedure within the MCO before they may file an appeal with the DMAS Appeals Division. If the client is unsatisfied with the results of the appeals process, then they have 120 days after the MCO appeal decision to request an appeal with the DMAS Appeals Division. The MCO appeals process affects the DMAS appeals deadline in that DMAS is required to deduct the time that the MCO took to issue its decision from the normal 90-day timely processing deadline. Now, the obvious first step in the appeals process is for a Medicaid client to notify the appeals division that they wish to request an appeal. The basis for the appeals process is found in the Code of Federal Regulations at Section 431.220. Under this section, any individual who requests an appeal because he or she believes that the agency has taken an action erroneously, denied his or her claim for eligibility or for covered benefits or services, or issued a determination of an individual's liability, or has not acted upon the claim with reasonable promptness. An appeal may pertain to an initial or subsequent decision regarding eligibility, a determination of the amount of medical expenses that an individual must incur, a determination of the amount of premiums and cost-sharing charges, or a change in the amount or type of benefits to which the member is entitled. Additionally, an individual may appeal a nursing home discharge, an MCO coverage determination, or denial of non-emergency transportation, as I've discussed earlier. The requirements for requesting an appeal are very permissive. That means that an appellant may file an appeal through any door. The DMAS Appeals Division prefers to receive appeals through its new AIMS portal. However, we still accept appeals by mail, fax, or walk-in on the old paper forms. We can also accept letters that are not accompanied by the appeal request forms, emails, and even requests written on a napkin if it contains all the necessary elements to open an appeal. Basically, under the Virginia Administrative Code, any communication from an appellant or his representative that clearly expresses that he or she wants to present the case to a reviewing authority constitutes an appeal request. But this communication should explain the basis for the appeal. The appellant is also free to attach any supporting documentation to their appeal request and we must consider it during the appeals process. I will reiterate that we prefer appeals through the AIMS portal because it allows the appellant to input all relevant data to allow the appeals division to process an appeal, which populates directly into the case management system. On this slide, you'll see screenshots from the portal on the left, as well as the old paper form on the right. The basic data that we need to proceed with an appeal is the client's demographic information, a description of the action that they're appealing, the date of the notice of action, and the responsible agency is also extremely helpful. The next section gives them a checkbox field to indicate the nature of their disagreement, and below that is a box that allows them to give a narrative description of their disagreement. When an appeal is filed, the Appeals Division may require additional forms depending on the circumstances, which are necessary for the division to validate an appeal. The most common of these is when the appellant wants to appoint an authorized representative. Obviously, a representative must demonstrate proof of their authority to act on a client's behalf in order for the Appeals Division to accept the appeal as valid. Our authorized representative form allows a client to appoint a family member, a friend, an attorney, or a representative from a medical provider or community services group to represent them. Additionally, the Appeals Division will accept an appeal from a representative who is notated in the VA-CMS case management system. We often require additional documentation to validate an appeal. For example, if a representative purports to be a power of attorney, a guardian, conservator, executor, or administrator of an estate, then we require the legal documentation appointing that individual to that capacity. We cannot simply accept their word that they serve in these roles. The Medicaid appeals process, however, is designed to be easily accessible, so it's not necessary for a client to have a guardian, conservator, executor, or administrator appointed simply for the purposes of filing a Medicaid appeal. Our form allows the prospective representative to attest to a statement that the individual is physically or mentally incapacitated and unable to act on their own behalf, with a detailed description of the incapacity. We also allow the next of kin to certify that a client is deceased and that no estate has been opened on their behalf. We also publish a good cause form that appellants can use to file an appeal if they have missed the 30-day timely filing deadline. A set of criteria contained with the Virginia Administrative Code, which I've discussed a couple slides ago, allows us to accept late appeals. For example, if the appellant was seriously ill, was prevented from contacting the division, did not receive the agency's notice of action, or sent the request for an appeal to another government agency in good faith within the time limit. We also will allow untimely appeals for unusual or unavoidable circumstances at the hearing officer's discretion. Under the Code of Federal Regulations at Section 431.244, the Appeals Division has 90 days to issue a decision unless the appellant requests a delay or fails to take another required action. We also receive an extension for administrative reasons or emergencies beyond the agency's control. When the appellant causes the delay, we calculate a new deadline using set formula which has resulted from a consent decree from a federal court case. MCO appeals operate under the same deadlines, but DMAS's 90-day deadline runs from the date on which the appeal was originally filed with the MCO. We should also discuss expedited appeals at this point. Under the CFR, an appellant is entitled to an expedited appeal if the normal 90-day timely processing deadline would result or would jeopardize their life, health, ability to maintain or regain function. In this case, client eligibility cases must be completed within 7 business days, and medical services appeals must be completed within 3 business days. In these cases, appellants will typically request that their appeals be expedited, and a manager within the Appeals Division must determine whether their reasoning meets the criteria contained within the CFR. If we determine that it does, then DMAS must complete all steps that are discussed in this module within the specified number of days. That requires quick action by the responsible agency. During the appeals process, there are several occasions on which the responsible agency should expect communication from the DMAS Appeals Division, requiring action on your part. First, of course, we'll notify you that an appeal has been filed once a manager has validated the appeal. When this happens, the appointed appeals coordinator at your agency will receive an email from the AIM system that a document is available in the portal. Our system does not send PHI by email, so you must log in to view the documentation. At that point, you'll be able to see the appeal request and any additional documentation that the appellant has included. The notification document will let you know the appellant's name, appeals case number, the hearing officer assigned to the case, and the date and the deadline for the submission of the appeal summary to the DMAS Appeals Division. Occasionally, appeals are filed without a notice of action, and the Appeals Division will be unable to obtain it from the VA CMS case management system. An example of this may be when an agency completes a manual notice of action or it is uploaded to DMAS, to which DMAS has no access. When we do this, we'll need to confirm that the action has been taken, and we'll request a copy of the notice. We may also notify you that the appellant is entitled to continued coverage during the appeals process. Continued coverage applies when a member is appealed termination by the effective date of the action, or within 10 days of the notice of action. When you receive a notice that continued coverage applies, you must reopen the appellant's case in the original A category without a gap in coverage within 3 days of our request to do so. You must also create a new notice of action to inform the appellant that their coverage has been continued solely for the purpose of the appeal. This avoids confusion as to why the reinstatement action has been taken. You must also send a copy of the notice to the Appeals Division. Next, we will reach out to you through the AIMS system to confirm a date for the hearing. Our scheduler will select an available slot from the hearing officer's calendar, and you must go into AIMS to confirm or decline the hearing. If you have not responded to the inquiry within 5 days, we'll reach out to request that this task be addressed. Finally, we may need to reach out to discuss various procedural matters with you on a case-by-case basis. I would like to take one more moment to discuss the continue coverage process because it's an important right of the appellant, and we want to ensure that local agencies are complying with federal law on this point. Under Title 42 of the Code of Federal Regulations at Section 431.231, the agency is required to reinstate coverage if the appeal is requested prior to the termination date or if the appeal was requested within 10 days of the notice of action. When we notify you that coverage must continue, the appellant must be reinstated immediately in the original A category. However, continued coverage does not apply if the only dispute is one of law, be it federal or state. It's important to remember that federal law prohibits gaps in coverage when an appellant is entitled to continue coverage. That means that local agencies must act quickly. The Appeals Division requires that coverage be reinstated within 3 days of our notice and continue until an appeals decision is rendered. Further, it's important that you issue a new notice of action that indicates that the coverage is only being reopened as a result of the appeals process, and to provide a copy of the notice both to the appellant and the AR as well as to the hearing officer. Regarding communication, one point that's critical to remember is that you must never communicate directly with a hearing officer outside of the hearing itself. This is known as ex parte communication, and it is prohibited because it may have the effect of biasing the hearing officer's decision. Ex parte communication is any communication with the hearing officer outside the presence of the other party, whether it's the client or the authorized representative, and regarding the substantive aspects of the appeal. Any written communication that is sent to the hearing officer must clearly be copied to the appellant and their representative. However, we prefer that any written communication be uploaded to the AIMS portal or sent to the Appeals Division at the appeals@dmas.virginia.gov email address so that it can be screened before it reaches the hearing officer. Additionally, hearing officers are trained to stop any phone call once they realize that a party is attempting to engage in ex parte communication. Instead, they will direct you to contact their manager or a member of the support staff to address the issue. The next, and perhaps most crucial procedural step in the appeals process is the appeal summary. The appeal summary is important because it is essentially an informal legal brief that allows the agency to lay out the specifics of the action that they took. The Supreme Court noted that beneficiaries must have access to the evidence used to reach adverse determinations, and that it must be provided to the appellant during the appeals process. In addition to documentary evidence from the case file, the court stated that beneficiaries also have the right to testimony from the agency worker who took the action or who has in-depth knowledge of the action. These rights are important because they preserve the right to cross-examine and confront the DSS to put the eligibility determination to the test. This is why the appeal summary is essential. The appellant simply does not have the information to argue that a Medicaid eligibility determination was wrong, as is their right, if they do not know why and how the decision was made. That's why it's imperative that you provide them with a full case file, including any relevant documentation, as well as a description of the action and testimony to back it up at the hearing. Their right to cross-examine is an important procedural right as well. You'll see on this slide the first 2 pages of the appeal summary document that we've published. It gives the eligibility worker an opportunity to lay out the income, resources, household composition, and other calculations that they may have used to reach an eligibility determination. It also includes a narrative section, which is very useful because it explains what actually happened in the processing of the application. Please take note that it's insufficient to state cursory information about the case, such as the date and copy language from the notice of action itself. We've seen that before, and we have to send the summary back to the worker to complete a new summary because that summary did not comply with the appellant's procedural due process rights. It's also important for the reasons discussed above that the documentation must be attached to the summary to comply with the due process requirements. We have provided a checkbox section on this form for you to indicate what you're attaching. I have recorded a separate module discussing the appeal summary in further depth. Please refer to that module for more detailed discussion of the summary. We have discussed most of the requirements for the appeal summary on the previous slide, but please keep in mind that it's due within 21 days of the notification of the appeal. Further, Denovo Appeals, which are discussed in great detail in other Appeals Division modules, require that the DSS consider all new documentation that the appellant has submitted during the appeals process and issue a new determination or be able to explain in the summary and in testimony why the new documentation did not alter the original determination. Please also note that the appeal summary and accompanying documentation must be uploaded to AIMS, not to DMAS, and mailed to the appellant or the authorized representative. The DMAS Appeals Division does not have access to the DMAS system, and we cannot deem documents uploaded to that system to have been received by the Appeals Division. A failure to observe these rules will result in a delay of the appeals process and the appellant's receipt of a timely decision as required by federal law. The Appeals Division works with the Virginia Department of Social Services leadership to ensure that local agencies remain in compliance with these requirements. On this slide, we will discuss the reasons why the Appeals Division may reach a decision without a hearing. The first is a decision on the record. Under the Virginia Administrative Code, a hearing officer may issue a decision without holding a hearing if he or she determines from the record that the agency's determination was clearly in error and that the case should be resolved in the appellant's favor. These are rare but carry the same effect as a remand or a reversal, and the DSS must be prepared to comply with the instructions contained in this decision. A more common decision prior to the hearing is the administrative resolution. These decisions are appropriate when a subsequent action by the responsible agency makes the appeal request moot. Please keep in mind that the appeals process is a notice-driven exercise. The hearing officer only has the authority to address the issue that is present on the appealed notice of action, or is otherwise identified in the appeal request. If the subsequent action by the DSS effectively makes a hearing on that issue unnecessary, then the hearing officer may resolve the appeal. For example, verifications are a common appeal issue. If the agency considers verifications that were not received prior to the original notice of action and finds that the appellant would have been eligible for coverage, then the hearing officer can resolve the case if a new notice of action is issued. For other cases, we must be able to see that full coverage was reinstated back to the termination date without any gaps in coverage, or that the appellant has otherwise received the coverage that they requested in their appeal request. For this reason, it's important to send a notice identifying coverage that has been continued at the request of DMAS, if appropriate to the case, so that we can avoid confusion, as I've discussed before. Invalid appeals are those that we could not accept because they lacked proper authorized representative authorization, or because they were filed after the timely processing window, and the appellant has failed to meet our good cause criteria that I've also discussed previously in this module. Here, please remember the importance of a valid authorized representative form. We occasionally receive appeals from eligibility workers on behalf of their clients, and these are not valid. Appellants must submit appeals on their own, and the reason for this is that the eligibility worker is technically an adverse party in the appeals process and cannot speak for the appellant in the hearing. Withdrawals are pretty self-explanatory, of course. However, it's important to remember that the withdrawal must come from the individual authorized on the case. For this reason, we cannot accept a withdrawal request submitted through an eligibility worker, based solely on the word of the eligibility worker. The client must forward a written request or contact the Appeals Division directly to withdraw. Note that we can accept telephonic withdrawals from the party who is authorized to act on a case. And finally, note that a withdrawal is not effective until it's been accepted by the hearing officer. Hearing officers occasionally reject withdrawal requests if they are unsure that the appellant expressed proper intent to withdraw the appeal. Dismissals occur when the appellant has no right to an appeal in the first place, such as an appeal of an untimely processing of an application after the notice of action has been issued based upon that application. We also dismiss SNAP, TANF, and energy assistance appeals because we have no authority to hear those cases. Finally, abandons occur when an appellant does not appear for a scheduled hearing. The hearing officer will send a letter to the appellant and/or representative following a missed hearing and gives a reasonable time for a response from the appellant or representative. The case will be closed with no further action if the appellant either fails to respond to our letter or provides an insufficient reason for missing the appeal hearing. If we find that the reason for the missed hearing was justified, then we will reschedule the appeal with appellant delay added to DMAS's deadline for completing the appeal. Schedule letters are also essential to our ability to deliver due process, as they tell the appellant where, when, and how their hearings will take place. This was another important requirement from the Goldberg Supreme Court decision that I discussed earlier. Our AIM system now automatically generates these letters and mails them to appellants and authorized representatives, and also provides an email notice to the designated agency appeals coordinator that the schedule letter document is ready for them to view in the AIMS portal. Please, of course, note that we do not send out PHI from the AIM system via email, so the coordinator or worker must log into the AIM system to receive this document or any other documents associated with the appeals process. The schedule letter will also contain a reminder of the summary due date. It's important to pay attention to this letter because it describes how the appeal is to be conducted. Most hearings are telephonic, but some may be in person or over a separate conference line. Parties are expected to be familiar with the instructions and participate as instructed. The next few slides deal with the hearing itself. This one discusses briefly the hearing officer's responsibility in the process. First and foremost, they must conduct a fair and impartial hearing. All hearing officers are lawyers and are familiar with the requirements of due process as discussed in the previous slides. To ensure that due process is provided, they must maintain order in the hearing. Often they'll encounter appellants and sometimes agency representatives who attempt to speak out of turn, and hearing officers have the authority to control the hearing, including asking parties to stop talking. This is important because each party must be able to present the facts that they view as relevant to the hearing. Under federal law, an appellant must not be prevented from offering testimony that they find relevant during the hearing. Additionally, as I've discussed above, the issues in Medicaid appeal hearings are strictly construed from the appealed notice of action and from the appellant's statements on the appeal request itself. The hearing officer is not permitted to address issues outside of this defined scope. Therefore, it's often necessary to redirect the parties in the hearing back to the issue on appeal. Although hearing officers want to allow appellants to be heard and may allow them some room to speak as they feel like, so that they feel like their concerns have been addressed in the hearing. Of course, the hearing officer's primary interest in the hearing is to gather evidence that will support a legally supportable decision. So they will come to the hearing with a list of questions gathered from their preparations to answer questions raised from their review. Medicaid hearings are informal. So this slide describes the general process of each hearing. The informality allows the hearing officer to deviate as necessary, but this slide describes the vast majority of appeal hearings. First, the hearing officer will begin with an introduction of the participants, which will be included in the hearing record. He or she will then provide an explanation of the hearing process and allow for any procedural questions. This includes defining the issue on appeal, as I've discussed previously in this module. The hearing officer will next allow agency testimony about the action taken, the reason, and the authority for the action. Under the new de novo procedures, the hearing officer will also require the agency representative to address any new documentation and describe how it would affect the original determination and why it would not result in the approval of coverage. The appellant is then granted an opportunity to cross-examine the agency representative and question any of the testimony that's been offered. Next, the appellant will be allowed to offer any testimony or present any evidence that they feel advances their case. The hearing officer will be prepared with questions for the appellant and the agency representative as well. Finally, the hearing officer will allow closing remarks from the appellant and the agency representative, followed by closing remarks that describe any delay, record closure dates, and the final deadline for issuance of the Medicaid appeal decision. The final step in the appeals process is the issuance of the written decision. The DMAS hearing officer's decision is the final agency decision under the client appeals process. Any further appeals are directed to the appropriate circuit court under the rules of the Virginia Supreme Court, which is provided with each appeal decision that the DMAS appeals decision issues. DMAS appeals decisions come in the form of a sustain, a reverse, or a remand, and they may actually be a combination of the three if the hearing officer finds, for example, that some processing of the case was correct and other aspects of the case must be addressed by specific remand instructions. The hearing officer will provide a deadline, usually 30 days, by which the remand instructions must be complete and a new notice of action must be issued by the eligibility worker. If the eligibility worker fails to comply with the instructions, then the appellant has the right to file another appeal with the DMAS Appeals Division and question the agency's adherence to the remand instructions. As I mentioned, the appellant may appeal the hearing officer's decision to the appropriate circuit court, but please note that the Department of Social Services has no right of appeal from the hearing officer's decision. The DSS and the eligibility worker must comply with the remand instructions to the best of their ability within the time frame specified in each decision. Finally, this slide provides a quick flowchart of the appeals process, which we've discussed in this module. This concludes Module 2 of the Appeals Division Overview.